Hello everyone, good morning. I am Vidit Agarwal. I welcome you all to my YouTube channel VidiWise, which is a platform to mentor students for Judicial Services Examinations, for law entrance examinations like CLAT, both UG and PG level, and other various prestigious law entrance examinations. Students generally have the confusion when they start preparing for Judicial Service Examination, and these confusions may be like how to read the verdict, how to write an answer for mains examination. These confusions are quite nonsense, and I will try to clear these confusions with the help of a very small topic today, and the topic is cognizable and non-cognizable offence. You may be surprised to see that why this topic was chosen, because this topic may look very simple and it is quite short, but we have to see that we can discuss it at length in our today's class. Now we come to our topic, cognizable and non-cognizable offence. The term cognizable offence is defined under section 2 clause C. This is the first and the foremost requirement. Whenever you read any bare act provision, you must be very clear under which section and thereafter under which clause this definition is given. So you need to remember that the term cognizable offence is defined under section 2 clause C. It says that cognizable offence means an offence for which, and cognizable case means a case in which a police officer may, in accordance with the first schedule or under any other law for the time being in force, arrest without warrant. So from this definition we can simply make out that cognizable cases are those cases in which police officer has authority to arrest without warrant. Now we refer to definition of non-cognizable offence. It is defined in section 2 clause L, and it says that an offence for which and non-cognizable case means a case in which a police officer has no authority to arrest without warrant. So we can simply understand a basic difference between cognizable and non-cognizable offence. That is, cognizable offences are those offences in which police officer has authority to arrest without warrant, and non-cognizable offences are those offences in which police officer has no authority to arrest without warrant. Right? Now, first question we have on the screen is, under which section of CRPC the term cognizable offence is defined? You have four options on the screen: section 2 clause A, 2 clause B, section 2 clause C, and section 2 clause D. Now, if you have read the bare act provision clearly and thoroughly, then you can easily answer that option C is correct. Okay, this is one of the way of asking the question in the examination. Now we move to next question. It is section 2 clause C of the CRPC defines which of the following term? Option A, cognizable offence; option B, non-cognizable offence; option C, bailable offence; option D, non-bailable offence. Now again, if you have read the definition clearly, then you can easily answer this question that cognizable offence is defined under section 2 clause C. So option A is correct answer. Now we move to another question, and it will give you another dimension of how questions are likely to be asked in pre-examination. Question number 3. A cognizable offence is an offence in which the police officer has authority to arrest without warrant. The police officer has no authority to arrest without warrant. Offences which are punishable with imprisonment of more than 3 years imprisonment. Offences which are punishable with imprisonment of less than 3 years imprisonment. So again, we have read the definition and we can answer this question easily, and here also option A is correct. That is, cognizable offences are those offences in which police officer has authority to arrest without warrant. Similar set of questions may be understood with respect to non-cognizable offences also. Next question, which is very important, and if this question is asked in mains examination, and usually questions on differences have been asked in the examination for 5 marks. Suppose this question is asked in the examination that what is the difference between cognizable and non-cognizable offence? What you will write as a student? Only this much, what we have just seen on the screen, that cognizable offences are defined in section 2 clause C and non-cognizable offences are defined in section 2 clause L. and cognizable offences are those offences in which police officer has authority to arrest without warrant, and whereas non-cognizable offences are those offences in which police officer has no authority to arrest without warrant. I think every student who studies law or who studies CRPC, he knows this much. He can write, but we have to write an answer for 5 marks, and we have to justify those 5 marks. So we should dig deeper, and we have to find few more provisions in CRPC with the help of which we can understand what is exactly the difference between cognizable and non-cognizable offences. So now we will move to section 150. It falls in chapter 12. It is famously known as FIR. I will read the limited portion of the provision. Every information relating to the commission of a cognizable offence, if given orally to an officer in charge of a police station, shall be reduced to writing by him or under his direction and be read over to the informant, and every such information, whether given in writing or reduced to writing as aforesaid, shall be signed by the person giving it, and the substance thereof shall be entered in a book to be kept by such officer in such form as the government may prescribe in this behalf. Now, the word FIR is not used in section 154, but we know that information is given with respect to commission of a cognizable offence. So from here we can understand that information FIR is recorded. We can easily understand that FIR is recorded for the commission of cognizable offence. Now we move to next provision, that is section 155. What does it say? It provides that when information is given to an officer in charge of a police station of the commission within the limits of such a station of a non-cognizable offence, he shall enter or cause to be entered the substance of information in a book to be kept by such officer in such form as the state government may prescribe in this behalf, and refer the informant to the magistrate. Now here also information is being recorded by the police officer, but this information is being recorded in a different manner, and the information which is recorded here is called NCR, non-cognizable report, and the procedure prescribed thereafter is that police officer will refer the informant to the magistrate. So now with the help of this small discussion, we can infer that under section 154 FIR is recorded when cognizable offence is committed, and whenever non-cognizable offence is committed, then NCR is recorded by the police officer when information is given to him. Now we will refer to section 156 and we will see what else is provided there. Under section 156 it is provided that any officer in charge of a police station may, without the order of a magistrate, investigate any cognizable case which a court having jurisdiction over the local area within the limits of such a station would have power to inquire into a trial under the provisions of chapter 13. So now under section 156 we see that police officer has power to start investigation without the order of a magistrate. Now if we refer to section 155 subsection 2, what is written here? No police officer shall investigate a non-cognizable offence without the order of a magistrate having power to try such case or commit the case for trial. There is absolute bar on the power of a police officer to investigate a non-cognizable offence. He cannot investigate without the order of a magistrate. Without the order of a magistrate. Please remember this. Okay. So now with the help of these three provisions, definitions under section 2C, section 2 clause L, section 154, 155 and 156. We have figured out three major differences between cognizable and non-cognizable offences, and these differences are that in cognizable offences police has authority to arrest without warrant. Police, with the help of these provisions, we have figured out major differences between cognizable and non-cognizable offences. And in cognizable offences, police has authority to arrest without warrant. Police officer will also record FIR, and police officer also has the power to start investigation. And because he can do it himself without the order of a magistrate, so we can also say that police officer may start suo motu investigation whenever he finds that cognizable offence has been committed. To the contrary, if we refer to non-cognizable offences, all these powers are absent. Police officer cannot register FIR, police officer cannot investigate a non-cognizable offence, and police officer also has no authority to arrest without warrant. We can infer from this discussion that cognizable offences are definitely of serious nature, wherein prompt police action is needed, and non-cognizable offences are not that much serious, and we do not require any specific steps to be taken by the investigating agency. This was our one part of discussion wherein we refer to the Bail Act provisions and we analyzed the language of the Bail Act, and we try to understand that how questions are likely to be asked in examination, and how you have to write an answer for mains examination. Okay, now we have to move further and we have to discuss few more things, and this is something important, and I have figured out 3 important questions about cognizable and non-cognizable offences. Number 1, how to figure out the nature of the offence, whether it is cognizable or non-cognizable. Number 2, what are the myths about cognizable and non-cognizable offences? That is, cognizable offences are those offences punishable with imprisonment of more than 2 or 3 years, or cognizable offences are non-bailable, and non-cognizable offences are bailable. And number 3, why is the classification between cognizable and non-cognizable offences important? We will take up these questions one by one. Now, you may have read IPC, you may have referred to the definition of special law and local law under section 41 and 42 of IPC. We know that so many criminal laws exist in India. So what is the procedure, what is the way to find out the nature of the offence, whether an offence is cognizable or non-cognizable? So for that we have to refer to the schedules provided in the end of the Code of Criminal Procedure, and we see that there are 2 schedules, Schedule 1 and Schedule 2. Schedule 1 deals with classification of offences. It is divided into 2 parts, Part 1, Part 2. Part 1 deals with offences punishable under the provisions of the Indian Penal Code, and Part 2 deals with offences which are punishable against other laws. And Schedule 2 deals with forms, as you can see on the screen. If we refer to Schedule 1, Part 1, as you can see on the screen, and we further refer to this classification, then we can see that this schedule is divided horizontally into 6 columns: section, offence, punishment, cognizable or non-cognizable, bailable or non-bailable, by what court, triable. So if we refer to Schedule 1, Part 1, column 4, then we can easily find out the nature of the offence, whether it is cognizable or non-cognizable. Now, if we have to find out the nature of the offence provided in special or local laws, then for that we need to refer to Schedule 1, Part 2. And in Schedule 1, Part 2, offences are classified on the basis of the quantum of punishment, as you can see on the screen. I will take up this discussion when I will discuss the next question. Now, the next question for our discussion is, what are the myths about cognizable and non-cognizable offences? An offence which is punishable with imprisonment of 2 years or 3 years can be classified as cognizable, and if it is punishable with imprisonment of less than 2 or 3 years, can be classified as non-cognizable. Generally, it is provided in the textbooks that if any offence is punishable with imprisonment of 2 years or 3 years, then it is classified as cognizable, and if it is punishable with less than 2 years or 3 years imprisonment, then it is classified as non-cognizable. But this is not the reality. For reality check, we have to refer to again the schedule. If you come to the schedule, then you see that under section 143, as you can see on the screen, offence of being member of an unlawful assembly is punishable with imprisonment of 6 months only, but the nature of the offence is cognizable and it is bailable. Under section 144, offence of joining an unlawful assembly armed with any deadly weapon is punishable with imprisonment for 2 years and it is again cognizable and bailable. Chapter 20, offences relating to marriage. Under section 493, punishment provided is 10 years, but the offence is non-cognizable as well as non-bailable. So we can understand by referring to these provisions by way of illustration that the quantum of punishment criteria does not apply at least on offences punishable under the provisions of IPC. The nature of the offence, whether it will be cognizable or non-cognizable, does not depend upon the quantum of punishment provided for the offence. Rather, it depends upon the gravity of the offence. If offence is more likely to affect the peace of the society, then legislature in its wisdom provided cognizable nature for that offence. Now we come to Schedule 1, Part 2, Classification of Offences against Other Laws. Here if you see, if offence is punishable with death or imprisonment for life or imprisonment for more than 7 years, then offence is cognizable and non-bailable. If offence is punishable with imprisonment for 3 years and upwards, but not more than 7 years, then again offence is cognizable. But if offence is punishable with imprisonment for less than 3 years or with fine only, then offence is non-cognizable. So with respect to other laws, we can easily say by referring to Schedule 1 Part 2 that if offence is punishable with imprisonment of less than 3 years, then it will be non-cognizable, and if offence is punishable with imprisonment of more than 3 years, then it will be cognizable. Okay, so this is a very, very important thing which you need to remember, and you should not be confused by referring to any material, and you should be very clear with the help of this discussion that nature of the offence as far as IPC offences are concerned does not depend upon the quantum of punishment, and this quantum of punishment criteria applies only with respect to other laws, as we have discussed by referring to Schedule 1 Part 2. Okay, now the next question is that whether all the cognizable offences are non-bailable or whether all non-cognizable offences are bailable. So we cannot make any generalization, rather we should refer to the provisions of the CRPC and particularly the schedule. So if we refer to again section 143, then we see that offence is cognizable as well as bailable. If we refer to section 493, offence is non-cognizable as well as non-bailable. If we refer to section 494, then again offence is non-cognizable as well as bailable. So we can see that there is no correlation between the cognizable and non-cognizable offence and bailable and non-bailable offence. An offence may be cognizable and at the same time it may be bailable or non-bailable. Similarly, an offence may be non-cognizable and at the same time it may be bailable or non-bailable. So these two criteria should not be clubbed, and we should not make any generalization, or we should not form any kind of hypothesis. It may lead to confusions. Now, the last part of our discussion is why the classification between cognizable and non-cognizable offences is important. This question may be seen from the perspective of a law student or judicial service exam aspirant, and also from the perspective of a common man. First, if we look at this question from the perspective of a common man, we observe that several offences are committed in the society, and every time law enforcement agencies do not come to the crime scene. Or suppose if a person goes to the police station, reports a crime there, and finds that no immediate action is being taken, despite howsoever angry or stressed he may be on the happening of an untoward incident. Why law enforcement agencies do not come to the crime scene, or why no prompt action is being taken? The answer lies in this classification. Such reported offence may be a non-cognizable offence, and no immediate action may be necessary in the given circumstances. Now, from the perspective of a law student or judicial service exam aspirant, several legal technicalities are likely to arise if any action is taken in ignorance of this classification. Now I will recapitulate what we discussed in this video. We learned how to read the provisions of Bail Act, how to correlate the provisions, and also how to build the concept with the help of legal provisions, which will make our preparation for judicial service examinations easy. We will meet again on our YouTube channel Vidhi-wise with a new topic. By the time you watch this video, and please also like, share and subscribe to our YouTube channel Vidhi-wise, and also comment in the comment section if you have any query on this topic. Thank you very much.